Supreme Court has done according to the High Court to affidavit, original affidavit and then supplement. Yes, follow 20C281 2022 rules of recruitment. Now, what I was explaining was something important which has not been informed to your lordship. 2012 rules had not provided for any entrance test for teachers by the state. It had not provided. You on your qualification, some kind of a weightage used to be given, and then you would get selected. They challenged one of the 2022 rules, the same set of petitioners, before the Honorable High Court, that you cannot now convert this 2012 no test to a test now. Test for recruitment. They filed a petition, the petition stood rejected. They challenged the 2022 rules. And the same advertisement which was putting on this both the advertisement is challenged, the rules are challenged. One of the High Court rejected it. 9th of September, where they wanted to rely on this petition, I am informed, I am instructed, I was not appearing. This Honorable Court had dismissed.
Suppose the rules of 52 were challenged. And it is not very simple.
This is like petition and this.
So how can the rules like that is not challenged?
Manan, the 23, the advertisement is there was separate bit from that. Yes or not? By the same set of petitioner.
Maybe that argument is
no, I am from Manad.
I am not making a difference.
Manad, they trying to see the player here.
We can come to a different point.
I mean, yes.
You are saying that 42 rules, along with the July advertisement, it was challenged by the same set of petitioners, and the challenge was to the rules. What were the rules of the challenge in that?
Rules of 2020.
That is what
you have mentioned so. The Supreme Court Supreme Court order is the 9th of September. Oh, that's right, but the High Court order. Yes. Did you mention in your counter also? What did you mention? That they filed this petition dismissed and the matter is pending before this court. The High Court order you must be aware. It's not there in the counter.
need a second. If you want to do the same different thing. Petition 5, challenging the rules of 42. Which rule was advocated? Number 1.
The entire set of rules are advocated.
Some entire rules can be
they are incorporated in the order.
We can understand what is there. Then one thing, the another is advertisement. Which condition of the advertisement was changed? And suppose
they have challenged the entire rules and the entire advertisement on this ground that because they are, the 2012 rules are prevailing, they should get direct appointment. They should not go through this process, which is the subject matter here, saying that they should get direct appointment because they have been waiting.
They have a ability for appointment. They want to go with separate rules. What is the relevance of that?
maybe that is for rules. At present, 22 rules are in vogue. 42 rules, as per 42 rules, whatever is that of 40 qualification, 40 purpose of entrance test, it is not in dispute. So once it is not in dispute, then even they have challenge for that. And whatever the decision is dismissing that application, what may be a consequence to the present point? There may not be consequence of present point. In see, we are looking to left, Mr. What is the relevance of this? Mr. Manendra. Mr. Manendra, please.
Kindly see, my lord, page 281, I was shown to your lordship in reference.
Yes, please.
For reference to 2022. Then, my lord, your lordship may kindly come.
Yes.
As I hate that the state is not conducting that after 2016.
All right.
in continuation of that, kindly see para 7, 286 para 7. It is relevant to state and submit that the petition number 2 is the mother of one of the aspirant who is willing to participate in the selection process in the state but cannot do so because of the mandatory requirement of Ctet qualification, whose examination has not been conducted in 16. The petition 2 has come across several number of candidates who possess all the requisite qualification to be a part of selection process, but the state has made Ctet as mandatory. It is not being conducted in the state for last several years. And then what is announcement kindly come to the prayer. Page 289.
Page 289.
Last 3 lines, not prayer 8. For showing cause respondents, teachers eligibility test examination the state since the year 2016, in spite of regular demand and protest of large number of affected candidates, which is not only creating chaotic situations of law and order, but also mounting to ruining the aspirations of poor students who are merely aspiring to participate in the process of appointment for the post of teacher, which very much requires a candidate qualified Ctet as mandated under the provision of the National Council for Teachers Education guidelines, as per which such examination to be conducted on yearly basis. But unfortunately, no compliance by the state respondent gross violation of the guideline of NCTE and the rules of 2019, which are the Ctet rules. We are also the stipulation is contained that we will conduct it regularly.
But when we read this in true sense and spirit,
Yes.
then these petitioners as stated that as per NCTE, under RTE, NCTE is the authority which shall prescribe minimum qualifications for the purpose. They admit this part. EET is mandated under the provisions of the National Council of the Teachers Education Guideline, as per which such examination is to be conducted on yearly basis. Unlike this part, they are admitting for the purpose of examination because this relates to that holding of that examination, not on the way.
For showing cause is also how they will address the aspiration of large number of candidates available in the state of Jharkhand who have acquired all other requisite qualifications for participating in the process of recruitment of teachers in the state other than the mandate only because of fault, and that is on the part of respondent who have neither conducted the Ctet examination since 2016 nor have they taken a decision to recognize Ctet qualification.
So here they say recognize Ctet. Now come to next.
For directing the respondent to either conduct the teacher eligibility test in the light of the Jharkhand teacher eligibility test examination rules published, notification number so and so, which mandates the state authority to conduct the Ctet examination every year, and of the board to consider the Ctet qualification for participating in the selection process of the teachers in the state as per the policy of 2011. Now, but this, if you watch the kindly see, there is no argument of any 23(2). The only argument is that the NCT prescribes.
What they are asking there before the report, they are asking that we are aware CTET is not the qualification prescribed for the teachers test in the JTET in the rules of 22. So it is number 1, open and the regular test as per 2019 rules. Number 2, or CTET may be
Included for eligibility.
included for eligibility.
Correct.
Now for that purpose we have to look into what is the answer of the state.
Surely not. But what I will say, yes, but you actually kindly come to the counter 295.
Yes, please. Please, where we have to look into?
Number 295 it starts.
Yes, please.
When we come to 297 bottom paragraph 7. Where what the
You have taken it as a public interest litigation. So you said it is extent public interest litigation was filed for the following release.
yes,
Unlike that you have referred to the release.
yes or not?
Then you have started answering so and so. That is stated as submitted without parawise letter.
301 number.
Yes.
See para 10.
No, first line. You recognize RTA.
No, but that RTA nobody can run away. And that
We are only referring, Mr. Maninder Singh, they are not saying
yes,
anything.
RTA
Say what appointment as a teacher, is any of the school referred to clause N of section 2 of RTA Act, is he or she should possess a teacher's eligibility test, which will be conducted by appropriate government in accordance with the guidelines made by NCT.
So that is
So for the answer one part, this is next and come to time.
it is stated that if therefore the respondent is serious in implementing the provision of RTA, they choose period and data for which various consultations carried out by the respondent with different stakeholders. Better implementation of DET objective after looking to geographical and regional needs and requirements such as various language and tribal culture, Hindi language speaking, or to the extent difficulty before conducting a fresh DET examination. This is state of Jharkhand.
Yes.
11. That the COVID-19 monitoring workshops can skip.
Online.
12. So far, CET exam is concerned, center teacher eligibility test is conducted for determining the eligibility of the candidate for both the 1 to 8 in central government schools as and other school which does not fulfill the needs and requirement of the state, regional languages and other local needs, and whether to consider CET qualification as equivalent to Ctet in the matter of policy decision. Then, Lord, your watching can come to pen of 15.
Yes.
Respondent in the process to bring necessary amendments in the JTET exam to bring it on the quality and standard of CTET level. It's most humbly submitted that the respondents are going to bring some necessary amendments in the JTET rule, which is not
Rule 13 is also.
yes, not 13 ideas.
It is most humbly and respectfully submitted.
Respondent stated in the process of framing a rule for conducting first TET examination in the state of Jharkhand, which is under process, and due to which much time has passed for conducting TET examination in the state of Jharkhand. Then note 14, once the rules will be framed, it will be sent for cabinet.
Then 15.
15, the respondent in the process to bring some necessary amendments in the JTET to bring it on the quality of CET test, and what it's most humbly and submitted that the respondent will to bring some necessary amendment which are under process. Stated that the circumstances there on this country. So what the state response? Solely TET, about TET you are telling. Only about TET because the prayer is only for TET. Conduct of TET or CET be permitted. Eligibility. It's an eligibility test.
All right, please go ahead.
And one thing you admit here,
Yes,
the respondent is under process. JTT exam to bring it on quality and standard of CTT. That shows that your standard is low.
what happens is
What you are saying?
that if not the standard of CET for central schools and other schools does not necessarily mean that the standard in the state will be lower. But yes,
This is what you are saying.
it's always an aspiration for us that you must also be that not pedestal where you can say I am as good as anybody else. But that does not mean that I am not meeting the requirement of minimum.
That you have to accept because somebody is
One
wrong.
of the you establish, it indicates that further respondent is in the process necessary amendment in JTET exam
Yes, not.
to bring it
Yes, not.
on the quality and standard of CTET level.
Correct.
What does it mean?
But the
You are right. And the rules are not at par to the CTET. So you want to brought it to the CTET
so
level.
Lordship may also read it with paragraph.
Yes.
Read.
Yes.
Yes, read.
That so far as CET exam is concerned, CET test is conducted for determining the eligibility for teachers of classes 1 to 8 in the central government schools such as so and other schools etc. which does not fulfill the needs and requirements of state, regional language and other local needs, and whether to consider CET qualification as equivalent to Ctet in the matter of policies. We brought in the clause 10 of NCTE, and clause 10 made it only enabling for
Please go ahead. Go ahead.
clause 10 I have to come
We
in.
consider we are not looking go there. Come go ahead.
Yes, sir. So this is the reply which is given on
No, please go further.
para 16.
Yes.
It is submitted that the respondents are going to bring some necessary amendments in the JTP rule which is under process.
So this is you said this is misconceived. Then rejoin the affidavit. concerned here about that point that the CTET must be made applicable or not. You said clearly said one line, it's a policy.
No, I am saying something else.
So this is the first counter.
Yes,
Which is another counter.
yes. Let me show the second counter and then make my submission.
Yes, please.
315.
315. Supplementary counter.
Yes. It starts at not 314. And then what you watching the kindly see. Para 5. At 317.
There's some order of the court.
There was an order of 15 side 25.
The petition was raised.
Is that order?
25/7 order.
The vote of that also.
25/7. Yes, that is one order. You must have seen yesterday that the rate petition was filed before the
No, that's right.
One yes, order of 25.
Yes, I just give it to Lordship, no that order.
This order.
Counter affidavit.
Supreme Court counter. Supreme Court counter. Supreme Court counter.
Page 15, 15. 58, Madam Sir. Page 58. Same order where your Lordship has seen that proofs. Same volume. In the course of hearing, at page 58, not if your Lordship have got it.
Yes.
In course of hearing, Learned Senior Counsel, she is on for hearing for the petitioner in the lead case, would draw the attention of court to clause 10 of the guidelines for conducting T which is provided as supplement. I'm sorry, Your Lordship, this is my statement. May I read that one?
Yes, please.
In course of hearing, Learned Senior Counsel appearing for the petition, the lead case would draw the attention of the court to clause 10 of the guidelines for conducting TET, wherein it is provided at subclause B that a school referred to in subclause 1 and subclause 2 mentioned herein may also consider eligibility of a candidate who has obtained TET certificate awarded by another state duty with legislature in case a state government duty with legislature decides not to conduct a TET school at 1 and 2 in the state duty would consider the TET conducted by the central government. We are of the opinion the state government is genuinely creating a number of posts for the state TET examination required to be conducted, which has not been held at least for last 9 years. The examination was held in 16, then it should take into consideration the said provision. We advise the state to file a short affidavit stating whether they intend to allow these candidates who have obtained TET certificate from the central government.
No, read your counter.
Yes, now IBC come to para 5, 317. 317, para 5.
Yes, please.
The reference is made to this order, so your Lordship can skip para 5, para 6. It is sufficient that before going into the query, it is necessary to bring a factual aspect for proper adjudication. One of the essential qualifications of a person to be appointed teacher is referred to in so and so. He is RT acting that he should pass the eligibility test of Ctet, which will be conducted by the appropriate government in accordance with the guidelines framed by the institute. It is stated and submitted that state of Jharkhand is intending to implement the Jharkhand Ctet objective geographic assembly plot with regional needs requirements such as various languages, tribal languages, culture and key language speaking population within the state of Jharkhand. It is most humbly submitted that the central teacher eligibility test taken after the effort is basically concerned is conducted for determining the eligibility of candidates for teacher post class 1 to attend the central government school such as KNBS and KBS and others too. It is stated that the state of Jharkhand has formulated its own teacher eligibility test rule of 2019, dated 2019, which apart from math, science, social studies teacher stipulation for language teacher, to further prescribe for eligibility of teacher imparting education of regional language, other local tribal languages for the preservation of culture, needs and diversity of the state. It is stated that Jharkhand Teachers Eligibility Test Rule 19 prescribes for different eligibility criteria with respect to appointment of language teachers who are required to have qualification. At least one local language out of various local and tribal languages spoken in the state. That also would answer your question. One, either the regional or tribal Murad.
That is the rule.
Yes, that is stated that Jharkhand Council of Education Research and Training Ranchi is responsible for performing the important function of promotion of education research, improvement of education technique, practices and research, training development. Curriculum is in instructional and exemplar material method of teaching, techniques of evaluation, teaching data. It is stated that the Jharkhand Council of Education Research and Training, apart from aforesaid activity, publish and distribute books for regional and tribal languages free of cost, etc. Further, stated that there are enough numbers of JTT qualified candidates within the state and hence allowing CTT qualified teachers in the vacancies of the state and school-based graduates. Stated that there can be no doubt about the fact that the ultimate beneficiary of the recruitment process would be a large number of children within the state who would suffer if there is undue delay in the appointment of teachers. However, the state is at liberty to set the qualification, particularly when these qualifications are in accordance with the statutory guidelines framed by NCT. Please mark this sentence, not that it would be for the state to decide which amount of test is to be permitted, because that is the domain of the state and that is also not recognized and acknowledged in the NCT guidelines. It is further stated that petitions contain and place reliance on clause 10B of the guidelines for conducting teacher eligibility test, which provide that TET conducted by state government, which legislature shall apply to a school.
To complete this,
Yes. School of the state government duty with legislature and local authority referred to in subclause 1 of clause N of section 2 and a school referred to in subclause 1 of clause N of section 2 of RTI. The guidelines further provide that a school at 1 or 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state duty with legislature. In case a state duty with legislature decide not to conduct a test, a school at 1 and 2 in the state duty would consider the test conducted by the state government. And that it is further stated, central TET qualified candidate or candidate qualifying TET by another state can only be considered for a state-run school when a particular state government has decided not to conduct its own test. Submitted that it's not the case of the state government has decided not to conduct the JTET, and these circumstances state government is not bound to consider central TET or a candidate qualifying TET by another state UT as eligible qualification. The CET qualified candidate can be made eligible in a given contingency where the state government is not conducting TET, but when the contingency does not exist, there is no occasion to make central TET candidate eligible or to allow those candidates who obtain TET certificate from central government or any other state. This is not submitted that there has been certain contingency due to which regular JT examination could not be conducted regularly, and hence the state is intending to allow age relaxation to the candidate for upcoming vacancies. Moreover, it is also intended to conduct JT examination before start of fresh recruitment of teachers within the state. Taken the issue whether to consider CET or PET from is a matter of policy decision of the state government. I read and understood, so but
before this date, the advertisement had to be issued.
Before this date of filing this affidavit. This
is 14th August.
14th of August.
July advertisement was there.
Advertisement is issued on
July.
9th of July.
July.
Yes, you're actually right. I'll come.
we'll come back. Feedback.
Yes.